So as I'm sure you are aware by now, yesterday the VA halted the new interim rule that would have changed medication effects to your disability rating. So now the big question is, does Ingram v. Collins control again? And more importantly, what does this mean for your claim right now? The VA issued an interim final rule on February the 17th, which has since been halted. The rule said disability ratings would be based on symptoms with medication, which overrode the court's decision in the Ingram v. Collins case that said otherwise. So, what governs now? So, strictly in my opinion, just my opinion, and I'm not an attorney, but if the rule is halted and not in effect, then yes, Ingram likely becomes the controlling interpretation again, and the VA must follow the court precedent set by that ruling, unless overturned by a higher court or replaced by a valid final rule. So, in plain English, the VA may not be allowed to rely on medicinal improvements if the diagnostic code does not mention medication. And further, under Ingram, if your condition improves with medication and the rating criteria from the 38 CFR Schedule of Ratings does not specifically mention medication, the VA may have to consider what your condition would look like without that medication, which could mean that examiners must clearly explain your condition's original severity before any medication was used. And if the examiner skips this step, your claim might be sent back for further review. And it may also require going through a more detailed and thorough medical exam. So, how does this affect VA disability compensation claims? For new claims, it could require the examiners to cover these topics: how the medication affects your condition, and also address how severe your condition was before you started taking the medication. And it's also important to note that if the examiner doesn't address both, it could be considered a mistake and sent back for further review or clarification. So let's look at the cases of increase request. If your medication hides or reduces how severe your condition appears to be, you may be able to argue that the VA should not use this improvement caused by medication to deny you a higher disability rating. And for higher level reviews, a compelling argument could be made that the final decision affecting your claim incorrectly relied on the positive effects of medication to judge your disabling condition. And for the Board of Appeals, the board must follow decisions that are set forth by the higher courts. If the board does not properly consider how medication affects your condition, your case may be sent back for further review. It's important to have realistic expectations in regards to this halt and what it does and does not mean. First, let's look at what it does not mean. This does not mean you will automatically get a higher rating. And also, you will not instantly receive back pay. And it's not like suddenly every condition is going to be rated higher just because of this action. But this action does mean there will be more legal complexities in the system and more decisions being sent back for further review. And importantly, more variability between examiner outcomes. So proper conveyance of the severity of your conditions and symptoms will be very important for being properly rated. And also knowing and understanding your conditions and how they relate to the level of severity within the schedule of ratings under the 38 CFR, and knowing the evidence that matches up with that is extremely important, as much now, if not more so than ever. We're also more likely to see a lot more legal complications popping up, which could mean longer wait times. So yes, that means possibly longer delays in the disability compensation process. So the VA's logic on why they tried to change things to begin with, due to the Ingram v. Collins decision, were because Ingram could affect 500 plus diagnostic codes, according to the VA, and over 350,000 pending claims could have been impacted. Plus, according to the VA, it would require speculation about untreated conditions, and all of this could overwhelm the VA disability compensation system. So now with these changes on hold, we're definitely navigating in a period of legal uncertainty, which further reinforces the need to fully understand your condition, where it falls in the level of severity under the 38 CFR Schedule 4 Schedule of Ratings, and having the proper conversations with your doctors and the CMP examiners on these conditions and the symptoms associated with those conditions, which is a perfect segue into what should we as veterans do. First thing is make sure exam discussions, like I just mentioned, accurately describe real-world functional limits and clearly explain what happens when the medication wears off, any side effects that you experience while taking the medication, as well as any breakthrough symptoms that occur from taking the medication. And breakthrough symptoms are defined as issues that return or get worse when your medication wears off, even if you're still taking it. Veterans should describe these symptoms to show their real world challenges. And as always, do not exaggerate, but certainly do not minimize. Documentation and credibility matters now more than ever. So be sure that you do understand your file, understand your evidence, understand your claimed conditions, and go into your exams and your doctor's appointments with confidence in understanding this and knowing the outcome that's proper for your particular situation. Hey, if you found today's video helpful, please take a second, subscribe to my channel, put a like on the video to send it out to more veterans. And as always, I appreciate you watching. I'm Mike, and I will see you in the next episode.